Honorable Vice Chairperson, ma'am, thank you for giving me this time. As one of the means of alternative dispute resolution, the concept of mediation has been discussed in the country for a very long time. The August House is aware that mediation is a method of resolving conflicts, disputes, where two or more parties arrive at a compromise solution with the help of a neutral party, specifically a mediator. A mediator is not a judge, but rather a facilitator. While there are certain laws like the Companies Act, there is no standalone legislation on mediation. The mediation bill seeks to meet that particular requirement. If the bill is passed, it can change the legal and judicial landscape of the country for the better. Mediation is a cheaper and faster means of ensuring dispute settlement. It goes without saying that the judiciary in our country is burdened with a huge backlog of over 4 crore cases. We are well aware of the fact that it would take decades to clear all the backlogs. The mediation bill, which seeks to institutionalize mediation for civil and commercial disputes, as well as setting up of a Mediation Council of India, is a step in the right direction. The bill defines mediation as a process, whereby party or parties request a third person referred to as a mediator or mediation service provider to assist them in their attempt to reach an amicable solution to a dispute. This bill would provide a uniform procedure to be followed for mediation in the country. To my understanding, it would usher in a robust mechanism for solving disputes. Besides, mediation is not a new or recent thing in our country. It is something which has been in practice for centuries. In fact, it exists to this day, especially in rural India. Having a specific law on mediation would provide sanctity to this mediation process. Most importantly, a law on mediation is of the utmost necessity, given the fact that India is also a signatory to the Singapore Convention on Mediation. An effective dispute resolution process means reducing the burden on the courts, saving time, resources, and litigation costs among many, not to mention that it would have a significant impact on the economy, as well as promote the ease of living for citizens, access to justice, and rule of law. The mediation bill would be a game changer in many ways. The bill provides for the mediation process to be completed within a period of 180 days. Pre-litigation mediation has also been made voluntary instead of mandatory. Further, to fulfill the objectives of Digital India, the bill also provides for online mediation. Parties can also withdraw from mediation proceedings or request for change of mediator. Provision for international mediation has also been provided for in the cases where one party is other than that of Indian nationality. Under Clause 8 of the bill, a party may, in exceptional circumstances before the commencement of or during the continuation of mediation proceedings, file appropriate proceedings before a court or tribunal of competent jurisdiction for seeking urgent interim measures. The establishment of a Mediation Council of India will also go a long way in ensuring stability and smooth functioning of the mediation process. An important feature of the mediation bill is the community mediation, where any dispute likely to affect peace, harmony, and tranquility among families or residents of or any area or locality may be settled through community mediation with prior mutual consent of the parties to the dispute. Clause 28 of the bill provides that mediated settlement agreement resulting from mediation is final and binding and enforceable in accordance with the provisions of Code of Civil Procedure 1908, in the same manner as it were a judgment or decree passed by a court. There are many other provisions which highlight the rationality of this bill and why it is of utmost necessity to the nation. I have touched upon only a few crucial points which needs to be emphasized. As stated earlier, mediation will be a game changer. It will change the way that justice is delivered in the country. The fate of the common man will be restored. I say this with a sense of conviction, having witnessed conflict resolution through mediation. Take the case of my state, Nagaland. Most of the times, disputes are solved amicably and swiftly with the intervention and involvement of a mediator. In most cases, it is a village council between families. And we also have our customary court, where disputes are taken to the Dobashi court and solved there instead of going to the legal judiciary. Nagaland has seen its fair share of conflicts between the security forces and various Naga political groups, as well as between Naga political groups. Even in such cases, civil society organizations have played the role of mediators and have successfully brought an end to conflicts, as a result of which there is relative peace in the state. Although citizens in Nagaland can take the legal route, and which they do, majority of the Naga populace prefer to settle disputes by way of customary laws. Notwithstanding the fact that customary laws have always been a part of Naga society, most Nagas opt for it because it ensures swift justice, if that is the appropriate term. Even in cases of theft, robbery, boundary disputes, etc., one would find that mediation by a third party is the preferred method of settling disputes. The point I'm trying to make is that the proposed mediation bill will bring concrete and monumental changes. The common man, who usually has to wait for years, even decades, and will be able to breathe a huge sigh of relief once this becomes a law. In this country, justice for many is a luxury. We cannot allow it anymore if we are to move forward as a society. A country burdened with late delivery of justice cannot be a just society. With these words, I wholeheartedly congratulate our Honorable Prime Minister, Shri Narendra Modi ji, and our Honorable Union Minister, Shri Arjun Ram Meghwal ji, for this momentous bill, and I support this bill. Thank you.